Good day. So this is episode 14, and in this episode we will discuss Praeter Intentionem. If you miss our discussions on Aberratio Ictus and Error in Personae, you can visit or watch episodes 12 and 13 respectively. So in this video, we will discuss the concept first of Praeter Intentionem and then two cases where this mitigating circumstance was applied. Okay, the case of Wacoy versus People and the case of People versus Castro. So let us start. Praeter intentionem literally means lack of intent to commit so grave a wrong. It occurs when an offender intentionally commits a felony, but the actual injury or result produced is far graver or worse than what was originally intended. Okay, so for the first years, if you are asked the legal basis of this uh, principle, then you can cite Article 4 of the Revised Penal Code and Article 13, Paragraph 3, also of the Revised Penal Code. Under Article 4, it stated that criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended. For Article 13, Paragraph 3, since we mentioned that praeter is actually a mitigating circumstance, then stated there that the offender had no intention to commit so grave a wrong as that committed, and that is considered as one of the mitigating circumstances under Article 13. Before we apply this, or we can apply this, these elements must be present. First, that the perpetrator must act with criminal intent, no, against a specific target. So before you apply praeter, make sure that there is still first that element of intentional felony. The accused should have committed first an intentional felony. And if you notice in the cases that we will cite, the accused never denied that they committed a felony, only that they actually argued that the penalty should be lowered because of the presence of this mitigating circumstance. Next, there must be notorious disparity, meaning there must be a notable and clear disproportion between the means employed and the resulting harm. Diba? Parang inislap lang niya, tapos biglang nabagok yung ulo, namatay. So is the person who slapped the other liable? Definitely yes. But can we appreciate praeter? Then we need to check if these elements are present. Number 3, unforeseeable or unintended result. The grave result could not have been reasonably anticipated by the actor given the mild or restrained force used. Okay, so if these are present, then we can appreciate Praeter Intentionem. And again, the legal effect of Praeter Intentionem is that it is a mitigating circumstance. It does not exempt the offender from criminal responsibility. So kapag napatunayan yung mga elements, andyan pa rin siya. No? Liable pa rin siya, I mean. But again, as a mitigating circumstance, then it merely mitigates or lowers the penalty to be imposed. Okay? Now, let us apply Praeter, or let us see how Praeter was applied in the case of Wacoy versus People, GR number 213792, June 22, 2015. So what happened here? Here, at around 3 in the afternoon of April 11, 2004, prosecution witness Edward Benito, was eating corn at a sari-sari store located at Tublay, Benguet, when he heard a commotion at a nearby establishment. So, doon siya, merienda, tapos may narinig siya. Upon checking what the ruckus was all about, he saw his cousin, o pinsan pala niya yung nandun, Elner Arrow, already sprawled on the ground. While in that position, the witness saw Wacoy kick Arrow's stomach twice, after which Wacoy picked up a rock to throw at Arrow, but he was restrained from doing so. As Arrow stood up, he back punched him on the stomach, causing him to collapse and cry in pain. Thereafter, Arrow was taken to the hospital. So Aro was immediately rushed to the hospital and underwent operation for blunt abdominal trauma. However, Aro suffered cardiac arrest during the operation. He needs to be operated. So he suffered cardiac arrest, and while he was revived, he lapsed into a coma after the operation. Due to the financial constraints, Aro was taken out of the hospital against the doctor's orders, and eventually Aro died the next day. So that was the version by the prosecution. What was the version of the defense? Wacoy and Kibak denied the charge against them. They averred that while playing pool, they saw Aro drunk and lying down. Suddenly, according to them, Aro became unruly and kicked the leg of the pool table, causing Wacoy to shout and pick up a stone to throw at Aro, but Kibak pacified him. Both accused also claimed that Aro almost hit Wacoy with a 2x3 piece of wood, if not for Kibak's intervention. Wacoy ran, but Aro chased him and then tripped and fell to the ground. So another person, Kinikin, Aro's companion, followed Wacoy to the waiting shed nearby, cornered and kicked the latter, and the two engaged in a fist fight. Kibak came over to pacify the two and told Wacoy to go home. So this was the version, no, of the defense. So let's see, no, how did the court rule? First, the court ruled that there was no tumultuous affray in this case. For the first years, you did not worry about this. You would encounter this in criminal law too. Okay, but for those who are reviewing for the bar, the court held that since Wacoy and Kibak were even identified as the ones who assaulted Aro, then the latter's death cannot be said to have been caused in a tumultuous affray. Therefore, the court correctly held that Wacoy and Kibak's act of mauling Aro was a proximate cause of the latter's death. And as such, they must be held criminally liable, therefore, specifically for the crime of homicide. Now, let's go to the discussion about Praeter Intentionem. Be that as it may, according to the court, the penalty for the crime of homicide must be imposed in its minimum period due to the presence of mitigating circumstance of lack of intention to commit so grave a wrong, under Article 13, Paragraph 3 of the Revised Penal Code in favor of Wacoy and Kibak. In determining the presence of this circumstance, the court held it must be considered that since the intention is a mental process and is an internal state of mind, the accused's intention must be judged by his conduct and external overt acts. In this case, the aforesaid mitigating circumstance is available to Wacoy and Kibak, given the absence of evidence showing that, apart from kicking and punching Aro on the stomach, something else had been done, thus evincing the purpose of merely maltreating or inflicting physical harm and not to end the life of Aro. So, sabi ng court yan, no, na we can appreciate Article 13, Paragraph 3 because wala, other than kicking and punching, wala namang ibang evidence proving na balak talaga nilang patayin si Aro. But since namatay si Aro, then liable sila for homicide. Only that this mitigating circumstance will be appreciated. So at the end of the case, the court held that both accused were guilty of homicide, but the mitigating circumstance of Praeter Intentionem was appreciated. So the penalty imposed was mitigated. Now, let's go to the case of People versus Castro, GR number L-38989, October 29, 1982. So quite an old case. But here, let's see the facts, no? On how did the court apply Praeter here. At about 4:30 in the afternoon of November 17, 1971, Leonor Gata, aunt of the deceased 9-year-old Ferdinand Recoco, was looking out of the window of her house when she saw Castro, no, the barangay captain of San Juan, Pili, Camarines Sur, running towards Ferdinand, who was in the middle of the street. So si Castro yung accused natin. No? Siguro nagpapalipas ng oras, nakita ni Leonor yung kanyang pamangkin na hinahabol ng isang matanda because take note, Ferdinand here was only 9 years old. Hinahabol ng kapitan ng barangay. No? Upon reaching Ferdinand, yung bata, Castro boxed him with his left fist, hitting him on the right eye, followed by another fist blow on the left temple and a karate chop below the right ear. Ferdinand fell on the asphalt road, face downward. Leonor then went down the house and asked Castro why he boxed Ferdinand. Castro replied that he was angered when he saw Ferdinand box his 4-year-old son Eli. The deceased forthwith admitted having boxed Eli because the latter took a pot shot at him with a water pistol. So, away bata. Tapos, nung sinuntok ni Ferdinand si Eddie, nakita ng tatay. So, yung tatay, hinabol si Ferdinand at yun nga, sinuntok rin yung bata. So, after harm was inflicted, on the evening of the incident, Ferdinand developed a fever, and the following morning, Dr. Dalisay treated him for fever and right eye inflammation. After 4 days of treatment without improvement, Dr. Dalisay advised his family to consult an eye specialist. Thus, on November 5, 1971, Ferdinand was taken to the provincial hospital, where he received treatment from a certain Dr. Miraflores. However, he passed away on December 5, 1971, or 13 days after the original incident. That was the version of the prosecution. Let's now see how did the accused argue. According to the accused, at around 4 o'clock in the afternoon of the incident, while the accused was helping his wife sell fish at the public market in Pilica, Camarines Sur, his 4-year-old son, Eli, asked for merienda money, received biscuits, and began walking home. Along the way, Ferdinand approached Eli and boxed him. Seeing this happen a second time as he ran toward the scene, the accused hit Ferdinand on the face once and pushed him aside, causing Ferdinand to run away. The accused strongly denied delivering multiple fist blows or a karate chop, maintaining that he only struck Ferdinand once on the face before pushing him. So if you read the full text of this case, you will see that the accused did not really deny that he hit the deceased child. What the accused prayed here was actually for his penalty to be lowered, at least lowered. So he explored mitigating circumstances and proved that they were actually applicable in his case. And one of those mitigating circumstances is Praeter Intentionem. So how did the court rule? The court held that the testimonies of these doctors, yung sinabi natin kanina, strongly corroborate the defense version that the accused merely gave one fist blow on the deceased. And even conceding that he did deliver another fist blow on the left temple of the victim and a karate chop below his right ear, the findings of Doctors Dalisa and Miraflores strongly sustain the conclusion that these subsequent blows were not sufficiently forceful as to produce even the slightest contusion in the areas where the deceased was allegedly hit. Taking into consideration the circumstances under which the accused act was executed, as well as the marked disproportion between the means employed and the ultimate consequence thereof, then the accused claimed that he merely intended to chastise Ferdinand and not to do away with him deserves the full credence. On this premise, the mitigating circumstance of lack of intent to commit so grave a wrong should be appreciated in his favor. No? So that was the case. The court appreciated, among others, this mitigating circumstance of Praeter Intentionem. So the accused here was held guilty of homicide kasi namatay pa rin yung bata because of the intentional felony that he committed. But the following mitigating circumstances were appreciated. Number 1, lack of intent to commit so grave a wrong, that's your Praeter. And number 2, passion and obfuscation. Okay? I hope you learned something from this discussion and that you be confident in answering the questions of your professors when asked about Praeter Intentionem. Thank you very much for listening. Please do not forget to subscribe and comment what topic do you want me to discuss. No, we need those comments and free subscription for us to avail of the other features of YouTube so that we can post more videos and lengthy videos. Okay, thank you very much for listening.